the apartment was not a four-bedroom apartment. He's indicated that the owner of the property advertised that it was, and he went on the premises of the advertisement. Well, our position here and why it's going to be heard and by one of our tribunals is that the broker should be responsible to know the particulars of the transaction when it comes to what's available and what's requested. So the matter will be heard in July of this year, and we'll find out what the outcome is. The other thing that I wanted to make is we have been looking into the activities of our real estate licensees and how they advertise on the social networks like Zillow and Trulia. So we are keeping a close watch on that.
Can I ask are you looking for any particular things when you're looking at these ads on these online?
Well, we're just looking to make sure that they stay within the realms of their licensing requirements when they advertise. So right now it's premature, but we are just trying to make sure that, because that seems to be more upcoming now, but we just want to make sure that they stay within the authority of the law.
So you're going to begin to look at it more deep, but you haven't yet?
No.
Oh, okay. All right, thank you.
All right, so there ends my report.
Thank you, Anita. Next thing is one of our subcommittee reports, the Education Subcommittee. Sandra.
Yes, good morning, everyone. Good morning, yes, I would like to. The committee is getting closer to being able to submit a proposed curriculum, and I want to thank everyone who's been helpful in sending in information to Mark. It's been very helpful. Particular area the committee is focusing on, and we'll be adding quite a few hours to the topic called the Broker's Office, Operation Management and Supervision. The committee agrees that this is an area we really want to put a lot of focus in. And I just want to mention that we do have a tentative goal of September 1st to have this ready. That ends my report. Thank you.
Thank you, Sandra. Moving right along. So now we have some new business. The first thing up on our new business was some proposed regulation changes that Duncan had sent over. So I'm going to turn it over to Duncan to discuss those.
All right, good morning. The first one I'd like you to look at is the amendments to Section 176.3, the subject of study. As many of you probably saw last year, there was a very tragic incident of a realtor in Arkansas who was killed while showing a property. It is not uncommon for there to be incidents of some kind of criminal activity involved in showing a property or other real estate transactions. Our concern is that a lot of the folks entering the industry may not have a sense of awareness of what good practices would be to protect themselves in many of these instances. So we are proposing that an hour of safety be included in the qualifying course. To make up for that hour without extending the overall program, it's our experience that the 2 hours under the property insurance section probably is definitely a bit excessive. So we thought that it would be a fair trade to reduce the insurance hours from 2 to 1 and then create this new section for an hour program on personal safety. We have a motion to go.
Well, I don't know whether we want to just hand it over. Yeah. Anybody have any comments about that? Do we want to?
Diane Ramirez speaking. In that course, I think every location has different safety issues. For instance, in New York City, we very rarely deal with being in a car. At least in the Manhattan. So will it be geared to what the safety issues in each area of what you're selling is, or will it be more broad-based?
I would imagine that it could be done in either way. It could be tailored. There's a number of options. So at this point, we wouldn't be prescribing the exact curriculum, but I think obviously the experience of different regions would have to be reflected in the
Right,
coursework.
exactly.
Well,
I think
in
it could be given to the board. I think it could be given to the education subcommittee to develop the curriculum, kind of like they're doing for the broker curriculum.
Yeah.
All right.
I mean, in the qualifying courses presently, they have several hours that are left to the discretion of the region to bring up issues that are, galvanizing or very important to the region. So possibly we can be somewhat flexible since we already allow that in the qualifying courses.
Is in brokers courses. Yeah, I think that the 2 hours of local concerns, Eileen, is in the brokers curriculum.
Right.
So this is
This is the salesperson.
Salesperson.
No, I understand, but I'm saying we have a history already in a qualifying
Yes.
course. That's what I'm indicating.
Yeah.
And I think it's a good idea to give it to the education subcommittee.
Assign it to a subcommittee, have them look at it, flesh it out a little bit. It's pretty straightforward, but I said, if they wanted more details, I think we should assign it. I'm thinking we should assign it to the education subcommittee to at least kind of flesh out those differences that could be and how that would work within the.
With all due respect, I would say certainly the content would be something for the committee. I think this idea of just creating the hour is something we could certainly do through the board itself and then go forward with the details. It's still going to have to go through the rulemaking process, or perhaps not, depending on the consent nature of it.
Do a motion to move forward with it?
I would say.
Okay. All right, so why don't we do a motion to at least move forward with this at this point? I'll take a motion.
So move.
Daniel, second?
I second.
Second.
Madam Chair.
Okay. All right, everybody in favor?
Aye.
Anybody opposed? No? Okay, so then motion is passed, and we will move forward with this regulation change.
Great, thank you. The next item, we'll be dealing with section 177.3 and dealing with the hours, minimum hours of coursework for continuing education. It has been our experience through the realtors anyways that there are a number of really good learning opportunities that don't meet the 3-hour criteria. And in this way, we could create an opportunity for there to be less than 3-hour classes that would in fact be beneficial to the membership, to all realtors, or I'm sorry, to all licensees. So our proposal would be to allow 1-hour course sections. And then you've got the second part at 177.7. We want to, first of all, we want to standardize what an hour is. So under the qualifying course, an hour is actually 50 minutes. It was unclear whether or not in a C course it was 50 minutes or not. This would just make it very clear and put it into the regulations, and again, make it consistent across the board. But we also thought that if you are doing a shorter class, a 1-hour class, it's reasonable to expect people to be there the whole 60 minutes. There isn't really a need for a phone break if it's only an hour class. So that is the background of these two items, and I would move for its approval.
Comments?
Technically, we would need a second and then comment.
All right. Can I get a second?
A second.
Daniel, second. Okay, so any comments on it? Okay. All in favor?
Aye.
Aye.
Anybody opposed? Yeah, okay. So this motion will pass as well.
Thank you. The last item deals with section 175.25. There was essentially a drafting error in the advertising regulations, and it created the unintended consequence of not requiring the license type on business cards. That was never anyone's intent in any of our notes. It just was, again, an unintended consequence of a drafting error. So this would simply put back into the regulations what should have been there anyways, and what everybody thought was going into it when we approved it. As you know, these things kind of show up after they've already been done. So this is really a technical correction, because I don't think, at least certainly on our end, and I don't think anybody's raised the issue that the license type shouldn't be on the business card. And I so move.
Second? Second from anyone?
Second.
Second, Daniel? Good. Any comments? Okay, all in favor?
Aye.
Aye.
Any opposition? No. Okay, this motion also passed. Better than it went along. Anything else, Duncan?
Nope, that's all.
Okay, thank you. Next thing of our new business is rebate legislation that we're going to have Dave in New York speak about. Dave?
Hi. So in December of last year, there was an amendment made to Section 442 of the RPL, basically conforming to the department's prior interpretation of that same regulation, or same statute rather, which just clarified that it wasn't an unlawful fee splitting situation wherein a broker basically rebated a portion of their commission to one of the principals of the transaction where such services were not provided in, as consideration of them basically working without a license. So I've seen opinions going back at least I think a decade wherein the department has said if you're a broker and you're trying to incentivize people to list with you if you offer them a television or a trip somewhere or free gas or whatever, that sort of promotion, because it wasn't intended to reward someone for unlicensed activity, it wouldn't violate Section 442. So this amendment, which went into effect on December 17th, basically just codifies what the department's longstanding position on that rule was. So we think that it will actually help sort of the consumers because they'll now be able to sort of negotiate or accept these commissions where it was possibly the understanding that they couldn't, that if a broker said it was this percentage is my fee and that's what it was, there was no sort of opportunity to benefit the customer. So this just clarifies what the department's position has been. So that's sort of the update on the rebate legislation. I don't really have much else to say on that.
Thanks, Dave. I think, and hopefully I won't get this wrong. I think Sandra, you had sent us along an article that was in Crain's.
Yes, it's when the article came out, a few people, happened to mention it to me, so I thought it was important that the board have, just that everyone understands it, should questions come up at all. I don't know, has anyone had any experience? Has there been any confusion with it? I don't know.
I had an earlier discussion with Dave, and I think that the way it's written should be a little bit more confining, a little bit. And I don't say it in a positive way. I'd like to see it a little bit more bracketed, because my experience over the course of 20 some odd years is that when it's a little bit loose and it's not clear as who's really getting the benefits, and it becomes too creative for the entire industry to try and figure those things out. So if we're clearly stating that only the parties to the transaction, whether it is a seller or buyer, are the one that are getting the benefits, and not, we've stated before, a cousin that kind of like helped out, and now he's supposed to get a section of that commission as opposed to, it has to be very, very well defined, and I think it could be fantastic for the industry. People should be able to negotiate their commission without fearing that they're stepping or passing on any type of any laws that were created. But we need to put some kind of a clear bracket, and that's my opinion.
Well, I mean, with respect, I think, to part of that concern, the final sentence of that new amendment, I think, clarifies that such fee, commission, or other compensation must not be made to the seller, buyer, landlord, or the tenant for performing any activities which required a license. So with respect to this, hypothetical, if it was given to the cousin because they were, facilitating the transaction in some way, assuming that broker or the cousin in that hypothetical was unlicensed, that situation would still violate 442 in addition to other, provisions of the RPL. But, I guess, this is, a new amendment, but it's meant and intended to conform, I think, with the department's position. And so I guess we'll just have to wait to see if this actually becomes an issue. I don't think to some degree it will, because the department has always publicly stated basically what the rule is now amended to state. And so we haven't seen brokers being this creative in the last 10 years, even though this is what we've basically been saying. So I'm not really sure that we'll see those issues, but I guess we'll have to wait and see.
Can I ask you, listening to Joe, it just makes me question, if the rebate, both parties agree that there will be a rebate, are we saying, for instance, when the contract is negotiated and when the agent agrees to work on a property for a specific amount, is it at that time that the rebate is also to be negotiated?
I mean, not necessarily. To some degree, it is sort of like a business transaction. So if from the inception the contract calls for X percent, at that point they could certainly have that negotiation if it was necessary. But if for some reason something happens during the course of the transaction where a broker realizes, for whatever reason, as a business transaction, it is, purposeful or, makes sense for the broker then to say, look, I know we have this contract where you're supposed to pay me X dollars. I'll help out. I'll reduce it by Y dollars. Then that could take place at that point. Again, the purpose of the reduction or the rebate was not to reward or to be in consideration of the buyer, seller, landlord, or the tenant performing any activity which would have required a license. And then therefore it would not necessarily run afoul of the amendment to 442. So, I mean, it's to somewhat sort of like a living idea. You could do the negotiation in the beginning. If it's set so low, obviously the broker is going to not necessarily want to be in a position, I think, to offer a rebate later on. If they start off the contract and they say 1%, you're not going to go much lower than 1% if something happens. It's not to say it can't be done. It's not to say that it won't violate the rule, but the rule doesn't require or set limitations as to the time frame when this discussion takes place.
And it should be kept that way. I think it's great because as you go through the transactions, a lot of times we see that the last couple of percentage points are the difference between making a deal and not making a deal. So that flexibility should remain there. But we've also discussed situations where, principal in the transaction requires to make a payment from the broker to an entity outside of that transaction. We spoke about maybe making a donation to a non-for-profit organization of some sort, where the beneficiary will ultimately be one of the parties, but already now a link removed. Again, I mean, I just feel that those things should be bracketed. That should be clear. If somebody wants to make a donation on behalf of, because of a transaction, it should be directly, not through the broker. It should be directly by the party. It should be the seller, the buyer, or anyone who's a direct party to this transaction. And those are the area where I'm a little bit concerned that some over creativity will come and become a little bit more of an issue. And we've seen things. Let's just leave it like that.
Well, I guess I think then to some degree, if the creativity is so creative such that it crosses the line to either untrustworthiness or incompetence or even a breach of fiduciary duty, to some degree the 442 amendment is not necessarily going to be controlling because the department can rely on other provisions to discipline the broker. Again, I think the purpose of the rule in part was to conform to the department's prior position that in sometimes it's okay for the broker to give something back to the parties to the transaction, that it's okay to give a rebate or a discount. If, of course, the purpose was not to reward the unlicensed.
We're on the same page on this. I'm just asking that the way it's worded, it is bracketed and it's clear who's the beneficiary, and it should not be beyond that. It should not be a third party. No organization should be a beneficiary. It could be a form of a discount or handing back something to a seller, to a buyer, to a landlord, to a renter in order to facilitate the transaction. That's good business sense.
Right.
But taking it above that, above and beyond, on that stage we're perfectly fine. But taking it above that and getting, as I mentioned, those the cousin as in a theory, or a third person, or an organization, please, please pay them that check. We should not have, the brokerage community involved in that, and it should be very clear.
So, Joe, what I'm hearing from you is it should be to the party of the transaction,
Absolutely,
not at
directly
the
to the party.
direction
Not at the direction.
of the party to the transaction.
Well, I mean, that's what the provision actually does state. I mean, it does say pretty clearly that it's to the seller, buyer, landlord, or the tenant who is buying, selling, exchanging, leasing, renting, or negotiating a loan upon the real estate. So
Right,
again,
but I think what it sounds like is happening is, yes, they're receiving it, but they're saying instead of the check to me or the discount to me, would you write it to my cousin, or would you write it to my favorite charity?
right.
That's essentially what,
Yeah.
where the concern is coming from.
We haven't really seen that in terms of a investigation or a disciplinary action yet, so I think it would be too premature to some degree to try to really, render sort of a position that, how we would really interpret it. This is a new rule. I can say that, when we initially, or at least there was one instance where we had said because it clearly, inured to the benefit of the particular party to the transaction, and that both parties to the transaction, meaning the broker who was providing the rebate and the person who is, for all practical purposes, obligated to provide the money. In that instance, we said it was okay. Obviously, we can revisit that issue, and I think that's a good point, and perhaps that we will. But like I said, we haven't really seen this in practice, so I think to some degree these concerns might be a little bit too premature, because this is the same position the department has been giving for the last decade or so. This is just a statute conforming to the position of the department for many years. So I guess we'll just have to see how it plays out.
So what you're saying, or what I'm hearing, is that if we are asked to direct the money to someone other than the seller, that would be, as long as it wasn't for brokerage business.
That would be a consideration that we would, a factor that we would use to determine whether or not it would violate perhaps 442. That's not to say that just because it doesn't violate 442, that's not a lawful business transaction, because there are other statutes which could be used to prohibit the broker from doing that, like 441C and 443. If it was somehow coerced or pressured, and it would be seen as a possible breach of fiduciary duty, or if the broker knows that this wasn't actually a legitimate transaction, or if he had, violated some other provision of the general business law, if it was an unfair business practice. So this doesn't actually create this free-for-all situation. It just clarifies that if you're a broker and you want to give a rebate to your client, the seller, the buyer, landlord, tenant, and the purpose is not to reward them for the unlicensed activity, that's absolutely okay. And if the form of the rebate is in a brand new 60-inch plasma, or an actual, points on the commission, instead of 5%, it's 2%. Instead of 2%, it's 1%. Whatever it is, that's fine.
Okay.
But I think what you're using the word clarity, and I think this was done rightly to, confirm the practice and the opinion that the Department of State has had for the last 10 years, that you can for a party that's involved in the transaction. And clarity is not the same as changing what's right here.
Mm-hmm.
It's making it more readable and getting rid of what some people would refer to as, legalese, making it very, very clear. And I think what Diane was asking, though, is that a third party or someone, Jane Doe is the seller, and she's getting a rebate. You cut the check to Jane Doe. You don't cut it to any other entity that she says, well, I want my rebate to go to, or if Jane Doe wants to do that, then she can write out her own check or whatever. I think that's what Diane was looking for clarity on. And, I think as clear as we can be in these rules, the better off the consumer is and the better off the professional is.
I have a
question then.
Thank you for saying it
I
exactly
also have
like
a
that.
question.
Thank you.
That was, I think that is clear. We're all on the same page here.
Yeah.
You want to cut a discount to the buyer, to the seller, to a related party to the transaction. Do it. But if you're being asked to do it on behalf of, that's why you're putting some kind of a unnecessary burden on the agent himself. I mean, I don't know who's that organization I'm giving a check to. I never check them. You want to give a check to somebody, Mr. Seller, Mr. Buyer?
Well, again, this
You
is
do
just,
it on your here's the money.
I mean, the rebate, as I said before, to some degree was sort of the living negotiation between the parties. The
Yeah.
broker could say, look, here's your money, feel free to do with it what you will. I mean, that's sort of the resolution to it, if this is an actual issue.
Yep.
I don't know for a fact that this is an actual issue because it's so new to some degree.
So
No, it's not new,
Well-
because the Department of State has had this broker opinion
Right.
for almost 10 years,
But we
and there are
haven't
firms
seen-
advertising the rebates
Right,
and
but we
give
haven't
you
seen,
back, and
as
that's
far as I'm aware, I haven't seen
no,
this
no.
hypothetical.
But you're not in the trenches when
You're not
when
in
the
the trenches.
agent is being challenged, and we talk about people that want to do the right thing, but they're being challenged and pressured, and why shouldn't we write something that is very clear, not going out of the realm of what you have here, but making it clear that the rebate will be issued to the parties involved and not a third party. And that being said, you really then help the whole transaction.
Right.
So,
I mean, I think that we could certainly, the department can review the amendment, not necessarily to try to get the amendment changed, but to clarify it in terms of some sort of opinion to address this. And then, I think we could hopefully have something the next time the board
So
meets.
I have a quick question.
Sure.
So that kind of changes things, because I understand what you're saying. Sometimes your commission is challenged and then you reduce it or whatever the case, but that's not maybe necessarily the same thing. So now you're saying that you cut a separate check. So if you're cutting a separate check, that means, are you issuing this person, a 1099 at the end of the year? Are you that's what? Because I was thinking at the closing table, on the HUD, it would be a reduction
Right.
of your commission. But if you're talking about doing a separate check, then that's something your accountant is going to have to issue them something for, correct?
Yes.
I mean, I would assume so, yeah. I mean, that's why it's sort of a business decision that the brokers and the parties are going to have to make as to how they're going to handle
Yeah,
it.
we have several
It's
ideas.
beyond the business decision.
The
Yeah.
simplest form of this, and I think the intent was, I think the situation where you're describing where they're realizing rather than you pay the broker 10 grand, the broker is going to cut their percentage in half, 50%, so that the out-of-pocket payment from the client
Right.
is at the extra 5 grand. It's not necessarily them having to cut checks or anything like that, or giving them a plasma. It's just to clarify that the intent of the rule was always to prohibit rewarding the unlicensed activity.
I have another comment.
Sure.
What comes up a lot with multifamily housing and rentals is, first of all, the landlord, the owner of a property or the manager of the property is not allowed to charge a broker's fee to the tenant. And the Department of State, is aware of this, and this comes up a lot. Some brokers will say, well, the owner I have to give half of my fee to the owner. So how is that affected? Because in reality, as landlord, like say someone is getting their broker's fee from the Department of Social Services, they make sure, they look and see, are you managing this building? Do you own this building? You cannot get any part of the fee as the owner or the manager of that property, where the way this reads, it looks like the broker can rent the apartment, get a month and a half, say, and give a half a month to the owner. That's really wouldn't be correct then.
I think you can see there are a lot of different issues, nuances. As she said, she didn't quite echo my concern, but it's part of the whole broader issue. So I really do think an opinion on some of these issues would be very helpful to heads of firms as they educate their agents as to how to go out and present this in a professional manner, so that the consumer understands and so that there is no actual confusion in the industry. maybe all of us here that had an issue, we can write it in maybe 2 sentences and email it to Dave, and we'll see what comes of it.
I think that's a good idea.
Okay.
So
99 was a good point.
unless there are, I guess, any other questions, that was the only sort of information I had with respect to the legislative amendment.
Dave?
Yeah.
Dave, can I just interrupt
Yeah.
you for a minute? We've had New York City on the screen for quite the whole time almost now. Is Buffalo still there? Can we just?
We're here. We're just being quiet.
Okay, thank you. Just wanted to make sure we haven't lost you along the way. Okay.
Nope.
Sorry, Dave. Go ahead.
Not a
Thank
problem. So do you just want me to go to the next thing on the agenda, with the consensus?
Sure.
Um,
Absolutely.
So the next thing on the agenda is the update on the pending consensus rulemaking status. There are a couple of rulemakings that the department some time ago submitted for notice of adoption in the state register. These were all consensus rulemakings to amend various sections of Title 19. The comment period for that notice of proposal is actually expiring next week. So once it's expiring, we're hoping to file actual notice of adoption of those rulemakings so that they'll become effective as quickly as possible. So just a sort of a quick update on what those specific changes are. The first is an amendment to 175.12 relating to the delivering of the duplicate original. We're changing that, based on the prior discussions, no longer is required a duplicate original, but it'll just be a copy of the instrument that they're signing. Now with copy machines and Xeroxing and scanning, obviously duplicate originals are somewhat outdated. Second amendment is to 175.20B. To clarify the proper management of broker offices. Since the original reg was created, there has been a revision to the statute with respect to a branch office manager. So because the statutes weren't necessarily reconciling with each other, we're changing it to remove that it's under the supervision of the salesperson. An amendment repealing 175.20 in its entirety. The department is amending subdivision A of 175.24, which just clarifies the definition of real property to reflect what the statutory definitions are. Same change in, said that 175.24. Changing the provision in 177.2, providing that the continuing ed requirements will include the sales and technology. What is that for? Right, will permit the licensees to receive credit for continuing education classes, such as instruction in relevant technology, provided that such subjects are related to real estate industry and practices. And I think the final one, or rather clarifying the 179.1, that it's 2 years of full-time experience as opposed to 1. Changing subdivision B of 192, changing the points required for licensure from the 1,700 to the 35, as now there's 2 years, so that's obviously doubled. And then the final one is just basically to reflect the change that it's the 3,500 hours in subdivision 179.3A on the actual, I guess, syllabus or the points hours to reflect the 3,500 change. So as I said, these were all consensus rulemakings that we published the notice of proposal for. That comment period is set to expire next week, and so we hope to publish notice of adoption shortly. So that's all I have on the consensus rulemaking.
Thanks, Dave.
Dave, for the proposal we just approved for the business cards, do you think that could be a consensus rule?
I would.
You don't have to answer now, but I guess I would ask you to think about it. That would seem
Yeah.
to fit within the pitch.
That's something that I would have to consider. I mean, the issue with the consensus rulemaking in part is that if there are comments coming back which say somebody this is controversial or will cause confusion, we'd have to go back to the other rulemaking process, in which case it may make sense to just start with the regular rulemaking. But even before you get to the notice of adoption, as I'm sure you're aware, there's a whole regulatory process that we have to follow. So just making that decision as to consensus versus regular won't necessarily mean the reg will be promulgated any quicker. In theory, it's supposed to, but that's just theory.
Okay.
And so that's all I have on the consensus rulemaking.
Thank you, Dave.
Yep.
Okay, so those were new business that we, had on the agenda, but certainly we'll entertain any other new business. I know Duncan has indicated to me he has some additional new business.
We have a broker-owned title insurance committee. Yesterday, the Attorney General and the Department of Financial Services announced some regulatory proposals involving title insurance companies. It will have an impact across the spectrum of title insurance company owners. And I guess I'd like to have that regulation reviewed by the committee. I don't know if I need approval for that, but
Probably get a copy of it. Disseminated?
That'd be great.
Okay, yeah. If somebody can you get us a copy?
absolutely.
Okay, yeah, and Carol can get it out to everybody
Terrific, thank you.
for discussion at the next meeting.
Well, what we can do is have a committee meeting sometime between now and the next time the board meets. And
Okay. Okay. Thank you. Any other new business?
Yeah, I'd like to ask a question of, we lost reciprocity with Nebraska. Can someone tell me why that happened?
I'm not
aware of that either. Where did you hear
Well,
that, Eileen?
I went on the Department of State website, and because I frequently check things to make sure information we're giving out is correct, and because I know in different regions of the state, different things are important to people. I constantly am asked, who do we have reciprocity with? And I just, not that I personally care about Nebraska, but people I know care about having these credentials because they do business. And it wasn't there, and I wondered when that happened and why. And it would be interesting to know so that I'd have an answer. But, and can I ask, have we been approached by any other states for reciprocity? And have we granted it or not?
I have not heard of being approached by any other states for reciprocity, no.
No,
You know, that's
okay.
something that's considered, when somebody asks, then we have to look at both states and do an agreement, and I haven't heard of anything recently at all. But
Okay.
I'll look into the Nebraska one, and I'll see if I can find some history on when it was removed, okay?
And maybe why, yeah.
Right.
Because I'm always asked the why. And again, a number of agents, they do a lot of multi-state business, and it just makes their life easier if they can get reciprocity rather than having to work with an agent in that particular state. So I'd appreciate it. Thank you.
Anybody else have any other new business? Go ahead,
Yes, Diane Ramirez. This is something I've been asking for a while, and I'm told it's happening, but in practice, I'm not sure it is. When there is a Department of State complaint issued, rarely do we receive a letter saying the complaint was resolved. So we could be sitting out for a year or more not knowing if a complaint against us was resolved, dropped, moving forward. So as I said, I know the effort is there to have it done, but in practicality, it is still not happening.
No, I'd like to address that.
Okay, thank you.
Yeah, that was brought to my attention, and because you should be notified of
Yes.
the outcome of an investigation, and I'm going to look into it and be assured that we will make it more of an effort to do that if we haven't been doing so.
Great, thank you.
I'd like to bring up something else. We're all seated here and we're all trying to make sure that real estate transactions have as little issues as possible. And we're charged with looking at rulemaking so that our professionals can provide the best service to the consumer as possible. And I think that, our rules and our licensing processes have to give a bare minimum assurance to the public that they are working with an individual that has basic comprehension and basic critical thinking skills, so that they can read the massive amount of documents that are required for a transaction, that they can understand when it comes to negotiating the numbers that are involved. And I don't know how, I never noticed this before, but when that V8 moment comes and you hit your head, in our requirements for a licensed real estate agent, we don't do what several states do. The bare minimum of requiring a GED or a high school diploma.
I agree.
And, we're all for professionalism. But I mean, the state of Florida, the state of New Jersey, the state of Illinois, the state of Oregon, etc., they require GEDs or high school diploma. To me, it's incomprehensible that we would say with confidence someone is licensed by the state of New York, dealing with hundreds of thousands of dollars of some family's life savings, and we cannot assure them that they have the basic skills. And when you look at other professions that require a GED or a high school diploma, it's kind of interesting. And I would even say other departments that this Department of State supervises, we have a 75-hour entry threshold, and we have barbers that have to do 500 hours to meet the minimum requirement to take this New York State exam. We have cosmetology, 1,000 hours of approved course of study. We have nail technicians have to do 250 hours of approved study before and pass the exam. So I think if we're keeping the threshold of a licensed salesperson at 75 hours, I would say to at least give the public assurance of basic reading and critical thinking skills, which can only be developed with a systematic approach, that someone have a GED. So that's my recommendation. Any comments from my fellow board members?
I agree.
I totally concur.
Absolutely.
Buffalo agrees. Although you can't see me.
No, now we can. You just came on. We no longer can see New York.
I think when they talk is when they.
Yeah, I mean, somebody told us that it's whenever site is talking, they come up. So Buffalo, we can now see you. We no longer can see New York.
So if I stop talking, I'll disappear.
Only if New York City starts to talk, apparently.
When has New York City not stopped talking?
Just so you know, that didn't bring you up yet. I think that could be looked at. I mean, we could probably bring that to.
My understanding, and I think that definitely has to be looked at, is that it's really statutorily driven.
Right.
Some of our statutes actually say that you have to have a high school diploma, and some don't. And I think that's where we put our requirements on our applications. whether that's a requirement, I think that would have to be looked at legally.
Yeah.
Whether we can mandate it without it being in the statute, but I think it's something we can look at.
Okay, yeah. So why don't we look at that, we can look at that at least initially, internally, we'll bring it to, Whitney's attention and work with, Dave as well to kind of check the statute and where it is there, if it is anything there, or where we can go.
I have two.
Let's start with mentioning it to Whitney, and then maybe we'll farm it out to one of our subcommittees.
Thank you.
Trisha
You're
O'Connor
welcome.
here. I know we're supposed to be doing over the website, the e-access, and there's two recommendations that I have for e-access. One of them being that when the schools finish the courses, that there's a login for them to input the grades of passing or not. Because we spoke about this in a previous meeting, it's just like an honor system, and I know you do random checks, but I've heard through, just talk of people talking that there are people who go in there and check the button and don't finish the course or don't even take the course. And I'm licensed in multiple states as well, and you cannot, if you do check off the button, it is a red flag that triggers that your school did not report it. So if there was a system where schools have to manually go in and report that this student passed this exam, then once they try to apply for the license, it would be flagged to them that they can't complete it until they complete it, or until the school uploads it on their end that it has been completed. And my second part of it is, I have about 20 agents working for me, and at times, like I said, once again, I'm licensed in multiple states, and when you go to get licensed in multiple states, I have to pull a license history from DOS to submit to that state. But I just think that as a broker, sometimes someone may come to you, and when someone comes to interview with you, they have their best face on, and you take their resume, and everything sounds good. But I think that as a broker, there should be something when I go in, I could ever see if they ever had any suspensions by DOS or anything revoked to make me turn around and say, you know what, this is not. Because if you have to go for a driving to work for MTA or Access-a-Ride, you have to get a report from the DMV of your license history so that employer can review it. And I think that this should be accessible to brokers so I can make sure I'm not bringing someone on my team that could be a liability for me without me having to request it or go further with it. Thank you.
I can address your two items quickly. But the e-access, New York, that is definitely what we plan on doing in the future, with having the schools being part of the online system. We've moved forward with something that's entitled the License Center for the state of New York, and it has the sales, the appearance enhancement and brokers. And we do have that piece built into it, where if somebody applies to the license, an email notification goes out to the school will validate it and it comes back in. So that is definitely part of the redevelopment of all of our disciplines going into the system. So it is in the future plan. So I just wanted to make you aware of that. And as far as the license history, that is something that we can consider also in the future. I know that we do have the ability for people to ask for license certification or license histories of individuals, so you can do that. There's a fee for it. So if a broker put a request in, they could get a license history of that salesperson. But it's just not available through the online system at this point.
Thank you.
But it will be taken into consideration.
I'd like to say something,
as
and
we move
I
forward.
do believe that. I believe that they do ask the question on the online system on whether or not a license has been suspended or revoked.
Yeah,
But as you said, it's the honor system, but we do ask the question.
I also have just a brief thing, but if the licensee was suspended or levied a fine by the department following a disciplinary proceeding, that is updated on the department's website, on our Office of Administrative Hearings website. So if you were trying to do a background into a potential applicant, you wanted to see if we've ever disciplined him, I'm not sure how often these are updated. I think we try to do a good job in updating them, promptly, but any decisions of the ALJs are on our website, so you could type in a broker's name and see if they were fined and what the reason was, or if we have a plea deal with the individual, those consent orders are also being published on the website as well. They don't go back, in perpetuity. Our retention schedule, I believe, is only 6 years anyway, so it'd be hard to get the physical document if you're trying to do like a really detailed search, because I know some people have been licensed for like 20 years plus. But the more recent stuff, I think, should certainly be on our website. All you do is go to the ALJ's website, and you can type in the broker's name. I think most of the judges and the decisions also have their UID number in it, so you'd be able to do a search by that as well, and then that'll pop up.
Okay. I'm looking at my notes from the last meeting, and I know at the last meeting I had brought to the attention, I found it very curious. I was speaking to someone who was licensed in the state of Idaho, and he said, Eileen, they have a really, really good thing there. And I said, what? And they said that they license salespeople, they license brokers, but that if you want to open a business and be the principal of a firm, you have to take a state course on a state operation course, business operation course. And I found that interesting. I brought it up at the last meeting, and I said, is there some way we could find out how that works, what's constituted, just for our own edification, to see if it's something that is, interesting. So if nobody looked into that, could somebody look into that for the next meeting?
Sure.
So you want to know, you want us to look into what the standards are in Idaho and see if that's what we want to do here?
No, well, to see what their broker operation course entails. They license a salesperson, they license brokers, but if you want to go and then open a real estate business, they require you then to take what's called a broker operation course. And I found that interesting. Why not look at what some other people are doing to see if it can improve our industry?
Well, this leads into what the Education Committee is doing in bringing up the hours. I think before it was about 4 hours. We're looking at 10 to 15 hours perhaps to put into the broker's office operation, management, and supervision, because we feel the current amount of hours is
insufficient,
woefully inadequate.
Right.
So we are. This is a big focus.
And that might help us as we're looking at this section. I thought that would be just something interesting to look at.
Did you say it was Idaho or Iowa?
Idaho.
Idaho, thank you.
So, do we want to look at it? Do we want to look at it, or do we want the education subcommittee to? Why doesn't the education subcommittee?
Yes.
Either way.
Okay.
Yes, we'll look at it. We will look at that.
Thank you.
Thank you.
Okay.
All right. Anybody else have any new business? All right, if there's not any new business, any additional new business, we could open up the public comment period. We could try to do this. Why don't we start with Buffalo? I know we have, Tom is out there. Tom, did you have any comments?
Yes, I did.
Thank you.
I have a question about reciprocity with Massachusetts. Now, I could be wrong about this, but I understood that Massachusetts will recognize a broker's license from New York State, provided residency is in Pennsylvania, or not Pennsylvania, in Massachusetts. Is that does anybody there know how that reciprocity works? The reason I ask is that we had a broker from Massachusetts who wanted to come to New York and get their broker's license here. the Department of State informed the person wanted to move to Buffalo from Massachusetts, and the Department of State said that that broker had to have a residence in Massachusetts. Now, I thought reciprocity is going to mean that if you're coming to my state and you have a license in another state, you can be resident in my state and we will honor that license. When you're coming the other way, it seems to me that sauce for the goose is sauce for the gander. You've got to be a resident of New York State. We tried to get that, but the Department of State said no. The requirement must be that if you want to get reciprocal license from Massachusetts to New York, you have to be a resident of Massachusetts. It seems to be a catch-22. You can't, it doesn't work. Do we know what that is?
Yeah, the reciprocal agreements, reciprocity is intended to allow you to qualify for a license based on the requirements in your state of original licensure. Once you are issued a license based on reciprocity, you can maintain the license using the education, continuing ed, etc. from that original state. But once you move into New York State, you no longer qualify as reciprocal and have to take New York continuing education. Basically, once you have a New York business or residence address, you're considered a New York licensee and must follow our requirements.
So they have to do the continuing ed, but do they have to do the qualifying courses?
No, but because you've used that reciprocal agreement to qualify for your initial license in New York State.
Okay, but you can live in New York State and still get the reciprocal.
Well, no. Once you establish a business or residence address on your license in New York, then you no longer are considered reciprocally licensed. So if you come from Massachusetts and you provide us with your certification, proof that you have a license there, your application indicates that your business and residence is in Massachusetts, we issue you a license, and there's no further requirement on your part other than maintaining the continuing education requirement in Massachusetts. Once you put a New York address on that license, we no longer would accept the education from Massachusetts, and you, like every other New York licensee, must take New York approved continuing education. But you never go back and have to repeat a qualifying program, because we issued your license based on that qualifying program in Massachusetts or whatever state it is that you've come from.
Hey, Tom, were you saying that the person was coming to you from being a Massachusetts licensed broker, coming to you saying, hey, look, I'm moving to Buffalo, I want to become a New York broker, and that they couldn't do it?
Well, the thing was that they had to take, this is what we understood, they had to take the 75-hour qualifying course or take the 75-hour and the broker's 45-hour qualifying course. So if they stayed in Massachusetts and applied, they would have gotten the reciprocal license. But once they moved here, then they would have been treated as but the person had already moved. They already moved
right, so
here.
At the time of application, there was a New York address indicated. That person would not qualify for reciprocity and would have to take the New York qualifying education.
Or left.
My question of you is that the same requirement in Massachusetts? If it is the same,
that's always been my understanding, that they would accept the same requirements from us, that it was reciprocal. They would accept our license, we would accept theirs.
It says, my understanding, it says in the requirement in Massachusetts that you have to be a resident of Massachusetts in order for them to honor the reciprocal license. You can't be, now, I don't know, maybe that's a
I think these agreements were made long ago, and I don't know the specifics of the other states and how they would treat a New York licensee. But at the time the agreements were made, I believe it was negotiated that we would accept each other's requirements similarly to qualify for an initial license.
I have just one other request. In 1996, I asked the Real Estate Board of New York if they would clarify the qualifying points for the broker. Recently, and it's about 250 hours or 250 points if you make a sale. Okay, so in this situation, we have a broker a broker wannabe, goes to the Department of State and talks to them, and they say, if you have a listing that sells, you don't get 250 points. If you have a listing and another broker sells it, they get 250. Is that correct, or was that miscommunication? Do you get the same 250 points if your listing sells and you're involved in that sale, or you get 250 points if you bring the buyer to the transaction? Or is it a split, 125, 125?
Yeah, well, we can get that.
We'd have
We'll have
to,
the application.
Hold on one second, Tom.
Okay.
I think you get points for listing.
We're looking for the experience on the application.
Yeah. It says a sale, 250 points.
Yeah. Yeah.
Sale, it's for the sale.
Says an exclusive listing, 60 points.
I'm not looking at the same thing you're looking at, Tom, I'm sorry.
yeah.
You know what? Tom, can we get back to you on that, Tom?
Offline.
Tom, we'll get back to you.
I've been waiting since 1996.
So you won't mind waiting another few days, right?
Can I, Keith, could I ask one more thing? Can I ask one more thing?
Sure.
Would the board consider this, that I think 3 hours for license law, that's just my take on it, I think is not enough for the student to understand those rules, regulations, law that mandate competency and trustworthiness. I'm asking if the board would consider taking from the commercial and investment property section of the 75-hour course, which is now 10 hours. And it's important, but 10 hours seems to be a lot of time. I'm asking if the board would consider taking 4 from the 10, put 2 in license law and 2 in valuation and listing procedures, so that those 2 valuation processes, those used to value residential property and those used to value commercial properties, would be in balance. And then we could have a little easier learning process for the people who have to get out to provide quality service.
I can take it at the real estate, the subcommittee.
Yeah, okay.
I think that's a good topic to, once they're done with the broker curriculum, to revisit the education, the salesperson's education.
Perfect.
Okay, so Mark and.
Hey,
and
Tom,
Connie.
can you send an email to, do you have Carol's email address? Or can we find it? If you could just jot that down, and then we'll make sure it gets to the subcommittee to pick.
Yeah, it's this.
Perfect.
I've got her email address right here. It's the top email address.
Excellent. I got it. Keith.
Okay, thank you, and we'll pass it along. Why don't we go to New York City? Somebody starts speaking, your picture might come up again.
I'm going to start taking this personally.
It did switch back and forth a couple of times. It did kind of work.
We have
so-
one person.
Okay, can you identify yourself?
Eileen Foss,
basic,
Hudson
right?
Gateway Association of Realtors. Hello, Mark.
Up, you're back on.
Yeah, I wanted to address what Eileen said earlier about having a standard of, I want to say, educational or intellectual competency when they come into the classroom. It's almost criminal to accept tuitions for people you know simply cannot pass the exams. But instead of a GED or a high school diploma, which has, I guess, been watered down over the past 10 years, 30 years, Could we construct or work with the education department to construct a minimum standards for reading comprehension in English and also the ability to, I guess, conceptualize. And this way they can continue with the course or suggest remediation if they've got language issues, or some may just understand that they're not capable of completing the course. It's really painful. We don't get that many in the class, but there's just enough where they try. They really, really try, and they're not going to make it. And you know they're not. And it's very sad. So an exam kind of let people know where they're going. Another suggestion, I know Priscilla had suggested that we incorporate safety into the salesperson's course. I agree with that. However, I think 1 hour is a little inadequate. On the other hand, the property insurance seems to be overblown. Just take property insurance out, incorporate safety issues into the agency class, which is the logical place to go, on having open houses, serving the public. You really get into a car with a stranger because the seller wants property sold and wants people visiting. There's an entire 3-hour discussion on that. Then we get into the math issue. The math issue, again, there's 1 hour of math, which could probably be satisfied by handing students the formula, a sheet of formulas, possibly having a tutorial afterwards for those who need remediation. 1 hour is inadequate for those who come in and don't understand those formulas. On the other hand, those same formulas are being incorporated into the investment section. So it's either redundant or it just reinforces the student's anxiety that they're terrified over math. So I'd rather just take it out and assume, again, they have 4th grade math skills coming in, and if they don't, they're going to have to learn very, very quickly when they're out in the field. And number 2, the investment section covers most of those math. So it's kind of a duplication, and safety is a real issue. We had an incident a couple of years ago where a woman was selling a co-op. The doorman was letting people in, and the woman, they found that people were backing up, and the doorman finally discovered that the woman was not answering let the next person up. She had been beaten to a pulp up there, and fortunately there was a doorman who was vigilant on that. But again, this is an issue which, I'm sure New York City probably would experience as well. Going into empty buildings, empty buildings. Again, there's a safety issue there. So that's it. Oh, I'm sorry. Yeah, there was one other item, and I'm probably blanking it out. I don't have a problem with changing the hours or the minutes to an hour, but I would like to have explicit instructions on how we in the class are going to implement the enforcement of that. If somebody is taking a 3-hour class and comes in 30 minutes late, do we deny them access to the course and tell them you're not getting credit for it? Do we make them sit during the 10-minute breaks after each hour? I mean, how is that going to be handled? So I want to say a crib sheet so I know just what to do with the course. That's it. Thank you.
We'll look at all those things can be considered, I think.
During the education.
Yeah. Anybody else in New York City? Okay, how about Albany? We have some visitors. Okay, in Albany, can we ask you to stand up at the, just so we can kind of see you? We have a podium up there. John, you want to go up?
No, I'm actually good.
You're good, okay. Everybody's good here. Okay. All right, so that ends the public comment period. Anybody have anything before we make motions to adjourn? Before we make a motion to adjourn, just want to point out that we kind of want to run the public hearing right after we adjourn the meeting. It's usually a pretty quick thing, usually open and close, but just so nobody gets up right when we say adjourn. Any additional comments from anybody? Okay, motion to adjourn?
So moved.
Okay, second? Okay. Everybody in favor?
Aye.
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 Nobody's opposed, correct? Okay, so the meeting is officially adjourned. So we're also required to, by statute, have a public hearing. So I'd like to open up the public hearing session and throw it to each one of our sites in Buffalo, New York, and Albany. We can start with Buffalo. I mean, if anybody has anything that they'd like to bring in front of the board.
Tom, I know it's been since 1996, but are you pretty good now?
It's nice. I just want to say to all of the board members that I'm enamored of how you dedicate your time to make us better at what we do, and I just wanted to thank you.
Oh, wow.
Thank you. You're not going to get any quicker of an answer, though. Still going to be another 10 years. We want to go to New York. Anybody have anything for the public hearing? Okay. How about Albany? So that will conclude the public hearing portion. We'll get together with tentative dates for the next meeting. Carol will contact everybody. With that being said, I want to thank everybody for coming today and participating. And thank you.